Well, hello everybody, and welcome back to your favorite show on the internet, Raw Filtered. Guy Plus, we're back in court. She literally started talking as soon as I went live. You can't get more perfect than that, folks. Welcome back, everybody. This is the afternoon session.
Thank you, Your Honor. And if you'd like, I can also address the Montoya case that you said you'd like to revisit. If you'd like to do that first or later. Okay.
Thank you.
You're welcome, Your Honor. Your Honor, we've moved to exclude cumulative experts and witnesses that the state has intended to call and put on their witness list. 44 fact witnesses, 13 expert witnesses. We have an 8-day trial, 5 or 6 days for the state, many of them duplicative for medical experts, multiple gun experts, multiple experts on multiple issues. And we're in this impossible situation, Judge, where we're a day and a half away from the start of this trial. And we have no idea the order of witnesses they intend to call, which of the witnesses they intend to call. It's severely challenging our ability to present a fair defense, to present and prepare for the witnesses that they intend to call. This is the time and past the time for the state to say, this is the case they intend to put on. These are the witnesses they intend to call, and give us some transparency into how this trial is going to be conducted so that can be conducted in an orderly way with witnesses that we're prepared for and on notice of. Thank you, Your Honor.
It's not an unreasonable request. Look at her face. Why does she look so...
I'm not quite sure how to respond to that.
Are you not planning on doing it?
Brian Carpenter is a necessary witness. Kent Jorgensen is a necessary witness. Paul Jordan, I'm going to decide whether or not I think I can cut him. I can't make that decision at this moment. The Haigs are necessary witnesses. Pietta's a necessary witness. Ziegler's a necessary witness. Let me tell you why. Even though...
Let me tell you why.
Mr. Baldwin told OSHA investigators there wasn't anything wrong with this gun. It worked fine. The problem with it was a live round. The defense is centered around the gun was modified. The gun didn't function properly. I've got... how many video exhibits have I disclosed to the court? 40? The reason that you've got so many is because that's how I prove to you that the gun was working fine, is because they're filming him and the gun works fine. He cocks it, it stays cocked. He decocks it decocks the way it should. He fires it fires. So my witness list and my experts are designed to deal with their defense. And that's what I'm supposed to do. That's what I'm allowed to do. So if they don't want to hear from the Haigs and Ziegler and Mr. Pietta, who's coming all the way from Italy, then they can give up on the silly notion that the gun was modified and that it malfunctioned. But until they do that, there's nothing I can do. I did reach out to Mr. Spiro with a thought about whether or not we could stipulate to the testimony of Mr. Gillette. Mr. Spiro, understandably, was not able to give me a quick answer because it was something that he needed to discuss with his client. And because Mr. Gillette lives in Virginia and is the explosives expert for the FBI, I couldn't just sit on my hands. But hope springs eternal. If we can come to a stipulation with regard to Gillette's testimony, I can strike Gillette. We may not call Dr. Carrillo now that we've heard from them. Finally, let's talk about transparency, that they're not pursuing the she died because she wasn't properly intubated theory. So we're going to hold Dr. Carrillo in abeyance. And assuming that this issue is never raised, as Mr. Spiro has indicated that it will not be, then she will not be called. But we certainly reserve the right to handle that however we see fit. It's entirely possible that we are not calling Shannon Prince. We will have
These lawyers need to learn
Geraldine
how to play
Conway,
nice.
because of the defendant's
Her voice is kind of whiny, isn't it?
public defense that he didn't pull the trigger. And I don't believe that we're calling Mr. Primo. So that's the transparency that you get from me now.
Oh my God! This is the transparency that you get from me now. Can you be any more
Just
of a
briefly, Your Honor.
jerk?
We've got Jorgensen testifying about set safety. We have Carpenter testifying about set safety. We have other people testifying about set safety. They want Mr. Jordan to come and testify about set safety in Montana. We'll deal with that separately. When you look at this witness list, 44 fact witnesses, 13 experts, four medical experts testifying. When you heard Mr. Spiro say we are not challenging the quality of the intubation or the cause of death, this is a witness list that is ballooned far beyond.
I'm waiting for her to like come back and say,
in a trial
like
of this
them
length.
apples.
And so we're asking for, it's a good start of the transparency. Appreciate what Ms. Morrissey said, but we need a whole lot more of that in order to put on a fair and efficient trial and to be properly prepared for the witnesses that they intend to call, or else we're going to have witnesses testifying over and over and over again about the same exact subject matter, which is exactly what we're allowed to move to exclude on the basis that it's cumulative and it wastes time. Thank you.
I agree with the
First of
defense
all,
on
I
this
have
one.
not looked at the witness lists, so I know the number because you all keep telling me the number, but I'm certainly not in a position to start telling the state which is a better witness for this testimony and which is a duplicative witness. This is their case, and they know how much time they have. You said you'd use 1 to 2 days well, what is it, 8 days? 8 days. And so the state knows what they need to do. With respect to the roles and responsibilities of producers, that's already out. Brian Carpenter and Ken Jorgensen are not going to, he's going to be talking, Ken Jorgensen's going to be talking about the safety, but he's not going to be getting into producers. And since producer is out, Mr. Carpenter's going to be left to do firearm safety. So I'm not noted, and I'm sure it's noted by the state. They're well aware of the time frame. They asked, and I said no for more time. So denied. All right, next up is state's motion eliminate to prohibit double hearsay containing CAD reports.
I have the CAD report in
Oh
front
yeah,
of me.
the double hearsay issue.
The narrative statements that I believe are double hearsay that should not be admitted are on page 14. Everything else I think is perfectly appropriate as long as the proper foundation is laid for the hearsay exception. So my complaints are just the narrative in 14, and because it's just inadmissible hearsay, I don't think I don't see anything that's terribly prejudicial in those statements. But at the same time, they're hearsay, and they're hearsay within hearsay. So that's all I'm trying to get rid of is page 14. Thanks.
Your Honor, I'll be similarly brief. Part of what we were going to argue was that we couldn't really do a meaningful analysis since we didn't know what exactly the state was attempting to exclude. We now have that information. Based on the court's directive, we are going to be engaging in a meet and confer after this. I think that would be an appropriate time for us to review what the state has just indicated they believe is objectionable. We will determine whether or not we believe that there are exceptions, see if we can reach agreement. If not, then we can bring this before the court. This should be a very brief analysis based on the number of things they're saying they object to. And I think we can present it to the court before we get started, either tomorrow or the next day.
Thank you.
Yes, Your Honor.
What is on page 14?
So, Judge, when you've seen these CADs in trial before, what it is police officers call in and they say such and such, and then it gets typed down, or a witness calls in and then it gets typed down. So that's all it is. And one of the reasons that I want to exclude it is because some of the information is just incorrect, and I see that in CADs all the time. For example, they're talking about who's been shot. 1 1041 shot in the chest and one male shot in the stomach. He wasn't shot in the stomach. I don't know how they got that idea. But those narrative comments are frequently incorrect, and they are in this case as they are in many cases. So that's it.
All right. Well, typically this information will come in.
Oh, yeah, for those of you who may have missed it.
So we'll see how that goes.
We talked on Megan's
All right.
channel. Proctor suspended
So-
without pay.
As long as it meets a hearsay exception, I'll let it in. You all can talk about it, okay?
Small victory, but delicious.
Defendant Alec Baldwin's motion limited to preclude improper opinion. Oh, we already did that one. Okay. Kent Jorgensen. Defendant Alec Baldwin's motion limited to preclude improper opinion and testimony from Paul Jordan.
I think we should go ahead and argue it because we haven't had a chance to listen about it. Go ahead.
Thank you, Judge. We've moved to exclude the testimony of Paul Jordan. Paul Jordan was not on the set in New Mexico in October of 2021. He knows nothing about what happened on the set in October of 2021. He said he read about what happened there a little bit on the internet, heard some hearsay from some witnesses, but has absolutely no knowledge whatsoever. And so what does the state want him to testify about? They want him to testify about what happened 2 years later in Montana. They want him to say Mr. Baldwin had difficulty getting on and off a horse and therefore apparently defies safety guidelines because a man with a hip replacement gets off a horse in such and such a way and therefore the cruise.
Okay, that's ridiculous. If that's the only thing he's going to testify about, he should be excluded.
Testify that Mr. Baldwin had an attitude. We asked him anything else. He said, I don't think so. Mr. Baldwin had an attitude. Trying to introduce evidence from what happened in Montana, completely different circumstances, different people, different reasons for the movie, different facts, entirely distinct.
2 years later.
2 years later.
Oh, boom.
Has absolutely no
Took the words out of my
bearing
mouth.
on whether Mr. Baldwin should be convicted of involuntary manslaughter 2 years before. Thank you, Your Honor.
Coffees for closes only.
Having already indicated I may cut Mr. Jordan off of the witness list, I will indicate that that's not what we would call him for. None of what Mr. Nick has said really is why we would call Mr. Jordan. Mr. Jordan was the safety consultant on the continuation filming of Rust in Montana. The unions required that the continuation of the filming have safety consultants who had complete autonomy, who could not be overruled because of the obvious issue that took place in New Mexico. What Mr. Jordan indicated is that Mr. Baldwin insisted, and that was his word, that he, Mr. Baldwin, not have to follow the safety consultant's safety recommendations. Stunningly. 2 years later. And we've given the court the law that says that subsequent bad acts are admissible. This goes directly to this ongoing willful and wanton conduct. It is just additional information of willful and wanton conduct. Thank you.
You know, this is the same 404B other acts evidence that you excluded with respect to what happened before. Now they're trying to do it after. There were no live guns on the set in Montana. They were not real guns. There's no possibility of harm with what they were doing. We asked Mr. Jorgensen, what did Mr. Baldwin do? He didn't say he was unsafe with guns. He said getting on and off a horse, an attitude. Has no bearing on Mr. Baldwin's use of guns on the set in New Mexico. And the case that Ms. Morrissey's alluding to is the Rijo case that we talked about with the 404B evidence, where the individual lied about his commercial trucking license application before, and that was the predicate act for the crime, and then lied about it after, which showed that A, he committed the predicate act, and B, he was aware his physical condition didn't allow him to drive because it was dangerous. That's not even close to what they're using it for here. They're trying to show that Mr. Baldwin had an attitude and didn't comply with horse riding regulations or safety guidance, and therefore was reckless with a gun 2 years before. There's no connection. It's highly prejudicial. There's no basis for admitting that evidence here, Your Honor, and certainly not from someone like Mr. Jordan as an expert.
Thank you. The court makes following ruling. This falls under Rule 11404, prohibited character evidence. Evidence of a person's character or character trait
Yes.
is not admissible to prove that on a particular occasion the person acted in accordance with a character or trait. So it's not coming in.
I
Thank
agree.
you.
Thank you. Next case.
All right. State's motion eliminate to prohibit hearsay statements allegedly made by the victim.
To try to cut to the chase here, I agree with the defense position that the statements that Ms. Hutchins is alleged to have made, and I indicated to the court that the vast majority of the witnesses do not support that she made these statements. Mr. Baldwin did not tell Corporal Hancock that she made these statements. In fact, he indicated to Corporal Hancock that it was a male who was telling him where to point the gun. Mr. Baldwin referred to that person as a he. In the context of that interview, it would appear that Mr. Baldwin was referring to Mr. Souza. So it isn't until later that Mr. Baldwin begins to create this narrative that it was Ms. Hutchins who was telling him where to point the gun, and that's how she ended up getting shot. So if Mr. Baldwin takes the witness stand to testify, I believe that it comes in for the effect on the listener. I agree with them there. The other witnesses, the other 2 or 3, I disagree. I don't believe that it has an effect on them as the listener. So these statements are highly unreliable. They are so unreliable that Mr. Baldwin himself indicated that the person who was telling him where to point the gun was Mr. Souza. So I don't want these statements that have absolutely no indicia of trustworthiness to be admitted by the 2 or 3 witnesses who seem to say that she said something. And as I indicated in the motion, those witnesses can't even agree with each other about what she said and how that could have directed Mr. Baldwin's conduct. All of them agree that Ms. Hutchins did not say, point the gun at me. There is only one witness who says that Ms. Hutchins told Mr. Baldwin to cock the gun. The other 2 witnesses who support that she said anything at all agree that she did not tell him to cock the gun. So I just want to get this ironed out before we find ourselves in trial and we have all of these completely unreliable statements coming in from witnesses who don't agree. Thank you.
So, Your Honor, first I want to start with the fact that we seem to have skipped a step in the analysis with the state. The state has, kind of initially, at least in their motion, jumped to whether or not Ms. Hutchins' statements would have fallen under the hearsay exception 8033. But there's another analysis that has to happen first, and that is whether or not the utterances or the words that were spoken actually even meet the definition of hearsay, period. First, it has to meet the definition of hearsay before you have to get into the analysis of whether or not there's an exception that applies. Because if it doesn't meet the definition of hearsay, the analysis ends there. It's not hearsay, so we don't have to get to the exceptions. So what we do is we look at the words that were uttered, and then we see whether or not it falls under 11801. And 11801A defines a statement, which it must be, as a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. And so what's central to that is that the words that were uttered have to have been intended and have been an assertion. And the case law is clear about what that means, and we'll get to that in just a moment. The second paragraph, paragraph B, has to do with the fact that the declarant is the person who made the statement. And then C is where we get again into what happens with the statement. And C says, hearsay means a statement that the declarant does not make while testifying at the current trial or hearing, so it's an out-of-court statement. And 2, that a party offers an evidence to prove the truth of the matter asserted in the statement. So again, central to all of the definitional pieces of 11801 is that the words that were uttered have to be intended as an assertion. And there is case law on that, which we have cited in our motion. And the case law very clearly indicates that non-assertive statements are not hearsay. And that means a statement that cannot be proven true or false. So an assertive statement would be, the car was blue, the light was green. That is something that can be either true or false. It's true if the car went through the light and the light was green. It is false if the car went through and it was actually red. Other words or utterances like commands or directives are not assertions and therefore not statements under the definition of hearsay. So for example, point the gun here, or let the gate down, or don't jump in the puddle. Don't jump in the puddle is a directive or a command, and it is not true or false. It's just a statement. It's a directive rather. And so by definition, it is not hearsay. It does not fit the definition of hearsay. So you don't even have to go into whether or not there is an exception that would apply. It doesn't fit the definition and the analysis ends there. And so in this case, what we're talking about is the statements by Ms. Hutchins, which would have been directives. Point it this way. Show me the action. Show me the action is not a statement that can be either true or false. It's a command to do something. And so therefore, under the case law, which we've cited to the court, it's clear that that is non-assertive utterances that therefore are not hearsay. So the analysis should end there. Because the state addressed these other issues, I will address them as well, although it's not necessary for the purpose of this analysis. So the state tries to say, state of mind, and I believe they just conceded to some degree that they said if Mr. Baldwin testifies, then his state of mind becomes relevant. The state misunderstands what the rule is with respect to the effect on the listener. There's no rule. Again, that's an instance where you say, okay, we're not offering it for the truth of the matter asserted, again, because there has to be an assertion, but rather for the effect that the utterances would have had on the listener. It doesn't say the effect on the declarant. It says the effect on the listener. And if Mr. Baldwin is being given directions by Ms. Hutchins, then it would explain why he did what he did, and that would be the effect on the listener. And we can look at the circumstances, the surrounding circumstances, to give us an indication that he did then rely on those statements. Now, lastly, the state also talks about that this would be potentially inadmissible because they're concerned that there's this disagreement between the witnesses as to whether or not she said anything or what she said or didn't say. The jurors, though, are the finders of fact, Your Honor. The jurors get to hear all of the testimony, and they get to make the determination about whether or not they think she said anything. If she did say something, what they think she said. That's literally their role. They are the finders of fact, and they get to make a determination as to credibility of the witnesses. And we actually have an instruction in New Mexico. There's an instruction, it's 14-5020. And that one says that, among other things, the witnesses can determine and consider the witness's ability to observe, the witness's truthfulness or untruthfulness, the witness's motivation or bias to testify a certain way, among other things. So the jurors are going to be instructed as to how to consider credibility and what weight to give the different witness testimony is going to be up to them. But I want to add that I think it's a little bit difficult for the state to argue that the admission of these statements is just unreliable, because we actually have in the statement of probable cause, which I have a copy here for the court's convenience if I may approach. And if the court will turn to the second page under the statement of probable cause, I've highlighted a sentence there, which states, and again, this is the prosecution's statement of probable cause, which was signed under oath. And we have Baldwin was practicing drawing and pointing the weapon for the scene with guidance and instruction from Helena Hutchins and Joel Souza. That's in their own statement of probable cause. And so I think it's a bit difficult for the state to argue that there's not enough indicia of reliability or relevance or import for this to go to the jury when it made it into their statement of probable cause. And so for those reasons, we would ask that the court deny the state's motion and allow that to commence. Thank you.
It's a good argument.
Cause number D101 CR 2023-00039. That case is no longer pending. Because when I took this case over, I had to make a lot of changes. But one of the changes that I had to make was getting rid of the person who wrote this for his inability to fully understand the facts of the case. So here's the issue. I have a transcript of Mr. Baldwin's statement to Corporal Hancock in front of me. This is Mr. Baldwin's statement. I believe my recollection is she was there, turned a bit like talking to him. He's saying Ms. Hutchins was talking to someone else, obviously not Mr. Baldwin, not the speaker. So I think she was hit in the right armpit, but this is all I know. And that is that I take the gun out in rehearsal where he wants it, very dramatic and very slow, trying to sneak up on them. I take the gun out, and as I take it out, it clears, the barrel clears, the hole, turn and cock the gun over here. I turn and cock the gun goes off. That's just one of his numerous statements where he indicates that it was a male who was telling him where to point the gun. So part of the problem is that, sure, the defense can come up here and say, this isn't an assertion, this is a directive. Their own client didn't say that it happened. Never at any point in time during this interview does he say that it happened. And the vast majority of the witnesses who were in the room don't say that it happened. Now, is Mr. Baldwin allowed to forget a detail, obviously a very important detail, and then testify different when he's on the witness stand to what he said to Corporal Hancock? Absolutely. But he's got to take the witness stand to do that. That's my position with the court. Thank you.
Okay, so are you pushing for him to take the
Following
stand?
ruling. First of all, assertions can be, or directives can be assertions. So I certainly
I'm a little
researched
confused.
that. But what I'm ruling is that the statements are not being offered for the truth of the matter asserted. That the statements were said in defendant's presence and had effect upon the listener demonstrated by his actions. I have done a lot of research on the case law to make this ruling as to whether the defendant has to testify to be able to get that exception in. And I have read many cases where another person testified that the defendant was there and that he heard these words. So I'm going to let it in on that exception. And then that will obviously be an issue for the jury. Thank you.
Makes sense. I'm loving this
All right,
judge
next
more and
up.
more with every word she speaks. Seriously.
I'm not totally sure where we are. Is it my motion to limit 11?
Well, just a second. We did the crew letter. I don't know how that happened.
I don't think we did do the through letter. We didn't.
Oh, we
the
didn't
through
do, just a minute. All right.
Okay.
We have P other as well.
Right. Yes, okay. Thank you. D1. All right, let's do the crew letter.
The letter to the crew that Baldwin, or that was sent out. I don't remember if it was Baldwin who wrote it or not.
So there's a letter written by, well, signed. I think Therese Davis wrote it, but I'm not 100% sure. I'm not 100% sure who wrote it, but there is a letter. There was.
Yeah. Okay, sorry. I'm fine. In my mind, I was thinking the crow, but yes, I'm ready to do the crew.
Okay, great. So I don't know exactly who wrote this letter, but I think maybe 24 or 25 of the crew members signed it. Only 2 of the crew members who signed it were in the church at the time of the shooting, and the letter basically says this was a safe movie set. But let's forget about the fact that a human being died and another one got shot. So they get about 1/6 of the crew to sign this letter. The other 5/6 of the crew apparently declined to sign this letter. It isn't something that I recall being signed by Mr. Baldwin. And there are only, off of memory, I think 2 witnesses who signed the letter who may testify in the trial. So what I don't want to get into is we've got a witness on the witness stand who's giving testimony about what they saw, what they heard, all of the relevant testimony. And then all of a sudden they get asked, and isn't it true that you and 25 others signed this letter saying that the set was safe? That obviously doesn't come in. That's hearsay all day long. And I'm looking at the defendant's response. The state's assertion fails to note that Baldwin's prior statements can be introduced by the defense to rebut a charge of recent fabrication. I don't know. I have struggled. This is in the last paragraph of the defense response. I don't really know what they mean because Baldwin, I don't think, wrote the letter and he didn't sign the letter. So I'm not sure what this letter would have to do with his prior statements to rebut a charge of recent fabrication. The defense has also indicated if a witness testifies in a manner that is inconsistent with the letter's contents, or if a witness raises the crew's position about issues raised in the letter, then the letter may be admissible. I disagree. It's a letter that is completely irrelevant. Not only is it completely irrelevant, it's absurd. As the defense has indicated, people hardly ever get killed on movie sets. So for a person to get killed on a movie set kind of inherently means it was a pretty unsafe set. So I filed
That's
this
not
out of an
exactly
abundance of
true.
caution. I was actually kind of anticipating when I filed it that the defense would say, we agree, we're not intending to introduce the crew letter, but apparently they'd like to try to get into it somehow. And I just want the court to be aware we've got major hearsay problems here. Thank you.
Thank you.
I don't know if I buy that.
This is one of those evidentiary issues that should really wait for the context in which it comes up or not. And the reason is this. You already heard the state say, we're going to put on the medic to say, I believe the set was safe, or the camera grip to say this was a safe set or not a safe set. To the extent any witness they put up says, the whole crew thought this set was unsafe, or they signed the crew letter and they get up and testify that it was an unsafe set, contrary to what they signed in the letter. We're not offering the letter to prove the set was safe. That would be the use that would not qualify under any hearsay exception, because we'd be using it to prove the truth of what's said in it. To the extent it comes up and we use it, it's only to demonstrate that a witness testifies inconsistently with what they signed, or their statement that the whole crew thought this was an unsafe set is inconsistent with what other crew members said in that letter. Not for the truth, but for inconsistency, for example, for impeachment, for example. And so the circumstances in which this come up could make it inadmissible, in which case we wouldn't use it to prove the truth. Or it could be highly relevant to what the crew member who signed it is now saying on the stand, and to be denied the opportunity to confront somebody who signed that statement, for example, who says something directly contrary to it, to not be able to put that in front of them to say, well, what you're saying conflicts with what's in this document. That's not hearsay. That's admissible. It goes directly to the testimony they are given. Second point, the Baldwin statements issue. The state said in its brief, and by the way, in this brief, Baldwin statements shouldn't be offered by the defense. Now, we have no idea what that means in the state's brief. Our point was, if we're going to offer his statements, or if they are, you have to wait and see the context in which that arises. We were just trying to preserve any right we have to argue that in one situation or another, the statements should come in or not come in. But I don't think there's a ripe issue for Your Honor to rule upon. We were just reacting to the state's one sentence in its brief, which we didn't understand. So out of an abundance of caution, we wanted to make the point that we're not waiving any rights on that. But I don't think there's a ripe issue for Your Honor to rule upon with respect to Mr. Baldwin's statements. Thank you.
I apologize. I was confused. I get it now. So I think we're agreeing generally, absent something unforeseen, that the crew letter doesn't come in as substantive evidence. So we'll deal with any outlying issues should they arise. The defendant's statements, if offered by the defendant, are inadmissible hearsay under 11801 as the party opponent. He is not his own party opponent. So I can introduce his statements because he's my party opponent. He doesn't get to introduce his own statements because they're hearsay. So I just wanted to have some record generally that the defense doesn't get to start bringing in the defendant's statements through other witnesses. That's all it is. And I'll make my objections appropriately during trial.
That's it. We're done. Thank you.
Oh,
All right, the court rules as follows. The crew letter.
Did you
is
just say
an
that's it?
out-of-court
We're done?
statement expected to be offered for the truth of the matter asserted, and as such will be excluded based on hearsay. It could not be used as a prior and consistent statement unless the testifying witness participated in the letter and the foundation is laid. It cannot be used for impeachment otherwise because what the witness testifies to about the conditions on the set is his or her
Karen
testimony.
Reed update. What
The
Karen
defendant
Reed
would have to
update?
bring in a witness to state otherwise, not use this out-of-court statement to impeach the testifying
Somebody
witness.
doing like a
To do
video
so
on
would
it or
be an
something?
end round against the prohibition.
'Cause
against
there's no
hearsay.
court
I
today.
think we're all in agreement. It just seems like we all said the same thing. Okay. Thank you. So that's granted today. All right, let's get back to the Crow. The Crow letter. No, it wasn't the Crow letter. It was inconsistent factual assertions. Yes.
It was no, I already covered it, Claire. I already covered
As Your
it.
Honor knows, we cited multiple cases in our briefs. saying
You're talking
the
about
government
Brandon
is a party opponent.
Lee,
Bruce
Bruce Lee's son,
made if they're
who lost his
inconsistent.
head.
It's black letter law in a number of cases. In fact, the state's brief acknowledges that it's black letter law. Your Honor mentioned the Montoya decision. I've read that, and this is consistent with our
Brandon Lee.
position. Your Honor,
That's
in that
that's
case,
the Crow.
the prosecutor said an opening statement to the jury, you are going to hear a witness testify that that witness heard another person say X. The second trial, the defendant said, I want to introduce the prosecutor's statement in the opening as an inconsistent statement in this trial. And the court said, Well, you're not allowed to do that because it's not an inconsistent statement. It's the prosecutor saying what the jury should expect to hear from someone say about what someone else said, double hearsay. And the court said, and this is really important, the prosecutor's opening statement to the jury was not an obvious admission of fact that might have constituted an admission of a party opponent. In other words, if it were, we'd admit it because that's black letter law, but it's not. It's a prosecutor giving a sort of preview, not making an assertion factually, and therefore it's not a party opponent admission. It doesn't come in. Here, the statements that we are intending to use are not comments on what the jury might hear from a witness who talks about another witness's statements. These are statements that are clear, direct. Miss Gutierrez-Reed's training of Mr. Baldwin would not have made a difference. Now they want to come in potentially in this trial and say, if Mr. Baldwin just did the gun training, it would have made a big difference. That is a direct inconsistency. It's not a comment about what a witness might testify about another witness's statement. The same thing is true about Ms. Morrissey's statement that Hannah Gutierrez-Reed is the autonomous decision maker, and so forth and so on. We've listed a number of these statements in the brief. These are direct factual assertions by the state in the prior case. The black letter law is that that's a party admission, party opponent admission, and therefore it comes in. The Montoya case is consistent with that, and therefore believe it supports our position that we should be able to introduce this at this trial. And that's, again, consistent with what the state told Your Honor to rely upon it in Justice Thomas's concurrence. If the prosecutor wants to make those statements, that's fine, but there's a risk of undermining the prosecution's case because the second defendant has every right to present them to the fact finder as contradictions. That's from their own case. And that's exactly what we're asking the court to allow us to do here. Thank you, Your Honor. And unless you have questions about the Montoya case. Thank you.
Is this a defense or a state?
It's a defense.
Which number is it?
I believe it was defendant's motion on limiting number 5.
Number 5?
I believe so.
Okay. All right, go ahead.
Your Honor, I would respectfully submit that the defense is narrowly reading Montoya. So you have 2 different trials of 2 different defendants. So the prosecution can say X in trial of defendant 1 with the facts that are available and still present a different argument with the same set of facts, but as to defendant number 2. And so the statements made by Ms. Morrissey during her arguments to the jury in Gutierrez applied to Gutierrez, applied to her culpability. That doesn't mean that the state should be bound or that the defense gets to introduce her statements to the jury in Gutierrez because they pertain to Gutierrez. This is a different defendant. And so the facts are they're still the same well of facts, but the facts that we're drawing upon for this defendant are slightly different than the facts on Gutierrez. And more importantly, even if the court were to find that, well, okay, statements by a prosecutor are admissions by a party opponent, the court still has to subject that decision to a Rule 403 analysis. And under Rule 403, allowing the defense to introduce the statements Ms. Morrissey made out of context, so they're picking and choosing specific statements they want to introduce, would create confusion to the jury. It would be misleading to the jury. So the statement that counsel indicated that Ms. Morrissey made about Ms. Gutierrez being the autonomous individual, that pertained to Ms. Morrissey's argument as it related to ammunition. With regard to another statement that Ms. Gutierrez was not rushed, but yet in this trial, one of the issues is the defendant rushed Ms. Gutierrez. She was not rushed that particular day on October 21st, but rushed on other days to reload the firearm. So these would be completely taken out of context, Your Honor, and the court has the discretion to not allow these statements to be introduced as admissions by a party opponent. And I think that Montoya does apply because these are arguments by counsel that the court should exclude at a minimum under Rule 403. Thank you.
I'm not buying it.
Just a couple minor points, Your Honor. the case law is not distinguishable because that was a defendant in one case, and then there's a defendant in a second case. That's the only situation in which the party opponent admission rule comes up. Every single time a defendant in the second case says, I want to have the fact finder consider the contradictions that were said in the first trial, and the court said, yes, you're allowed to do that. That's a party admission. Every single one of those cases involved two different defendants. And so trying to distinguish this case by saying, well, that's Hannah Gutierrez and this is Mr. Baldwin, there's not a single case where a party admission was allowed in this context where that wasn't the case, two different defendants. That's what the case law stands for. The element of confusion that the state is relying upon, they're saying, well, you have to balance 403. Every single case, black letter law, party opponent admission comes in, as long as it's not, hearsay upon hearsay upon hearsay, where a prosecutor saying, this is what to expect. That's not an admission. It's admissible. And so these 403 balancing was in play every single one of these black letter law cases where the court said it gets admitted. And as Your Honor knows, 403 is an extraordinary remedy. So to apply 403 balancing and say it'd be too prejudicial when the black letter law says, as a matter of law, it's not because you're allowed to introduce it, there's no case to support that, Your Honor. The statement should be allowed.
Thank you. The court denies the defendant's motion. This is
Really?
an issue that the court has discretion on. I'm not mandated to put it in. I have the discretion on whether to put it in. First of all, I don't think that what the prosecutor said in Hannah Gutierrez's case is relevant to a relevant fact. And even if it is a relevant fact, it's probative value is substantially outweighed by unfair prejudice and confusion to the jury. In addition, I don't think the theories are inconsistent, but a continuum. Hannah Gutierrez loaded the weapon with live ammunition. Defendant Baldwin took that weapon with live ammunition and, according to the state, failing to follow firearm safety as an actor on the set of Russ, which continued into October 21, committed involuntary manslaughter as well. So I don't see it as inconsistent theories or inconsistent fact assertions, maybe separately hanging out there in one sentence, but I'm denying the motion. All right, next up is the Pieta. Defendant Alec Baldwin's motion in limine to preclude improper opinion and testimony from Alessandro Pieta.
Thank you, Your Honor. The state intends to offer Mr. Pieta for two general opinions, maybe many subcategories, but to sum it up, two. One, according to the state's brief, that the gun appeared to have been broken when it was in
the
full
broken
cock
gun
position.
again.
And number two, the quality control standards that Pieta applies, the strength of the steel of the gun, and the overall condition of the gun when it left the Pieta factory. And they intend to do that because, according to their opening of the brief, to show the functionality of the gun on October 21st. But if you look at the actual trip this gun took after it left Pieta's factory, it went through a show, it went to a distributor, it went to Seth Kenny, and it went to this set. Mr. Pieta hadn't seen the gun leading up to his PTI for 7 years. He had no idea what happened to it. He had no idea if it was modified or not. He didn't inspect the gun. He didn't review the gun reports. He barely knew what happened in this case other than there was an accident with the gun. And so to allow him to testify about the circumstances under which the gun appears to be broken when he hasn't inspected the gun itself or looked at the reports or done any testing is improper testimony by someone who has not relied upon any information that an expert would need to rely upon to give that kind of opinion. First off. Second of all, the quality of the gun when it left, the steel strength when it left, has no bearing on 7 years later, or 4 years later when the accident occurred, what the condition of the gun was. The testimony that Mr. Pieta might offer on that could be wildly misconstrued by a jury, highly prejudicial, because it was hard steel and it was made with quality on December of 2017. Therefore, the gun was in perfectly working condition in 2021. There's an enormous gap there, Your Honor. And to offer that testimony from 2017, after so many things happened to that gun, as to the condition in 2021, is more prejudicial than probative. Thank you, Your Honor.
We have a made-up defense.
Oh my
of
God.
The gun was modified. The gun wasn't functioning properly. There's not a single witness who is going to support that. Not a single witness, including the defendant himself. Yet, the defense is going to be put forth. If I don't call Mr. Pieta, we're going to find ourselves in closing arguments, and the defense is going to say to the jury, you don't know how this gun was manufactured. Maybe there was a mistake. You don't have any idea what condition it was when it left Italy. It could have left Italy in this condition, and then it made it to EMF, and then it made it to Mr. Kinney, and then it made it into poor Mr. Baldwin's hands, and it malfunctioned. That's what they're going to do. I can't let them, so I am bringing the man who owns the manufacturing company to testify. Moreover, if the court recalls from our response, this is a conversation that Mr. Nickus and I had back right around the time that I initially dismissed against Mr. Baldwin, where Mr. Nickus said, this shiny hammer, the color of the metal doesn't match the metal on the rest of the gun. We think this is a modification. So then we get Mr. Pieta to come in because we want to know, is this a modification? Mr. Pieta says, heavens no. He says, I picked out that shiny hammer because we decided that we were going to make this gun look more like a Colt so that it could be used in gun shows. That's the purpose of his testimony, and it goes directly to their defense.
I have a question.
Sure.
It says, Mr. Pieta, you've talked about the parts did not leave Italy in their current condition and will testify to what Mr. Pieta can testify that the broken parts of the gun are Pieta parts. The parts did not leave Italy in that condition and will testify to what parts are broken. Mr. Pieta can also testify based on his knowledge of the parts and the internal working mechanism of the gun that the hammer, sear, and bolt appeared to be damaged when the gun was in the full cock position.
He said that during his pretrial interview.
I didn't see that.
He said it in his, I think he said it in his pretrial interview under questioning from the defense that, and let me look for it in his transcript if you want me to. I can do a quick word search on his transcript. Under questioning, he indicated that from looking at it, he could tell that it was, because he's Italian, I don't know that he used necessarily, I think he said it was in the firing position. I don't think he used full cock. And I think that was part of the language barrier. Do you want me to see if he said it in his, I can pull it up for you.
That's all right.
Okay.
Two things, Your Honor. That's exactly the concern we have about Mr. Pieta. He hasn't inspected the gun, hasn't reviewed the gun reports. To look at a picture of a gun he saw 7 years ago and to say, I think the damage occurred this way, that is not reliable expert testimony. He hasn't inspected it. He has no idea the conditions under which it was used, the conditions of the FBI testing. He hadn't even heard the FBI tested it, didn't know what was done. And so for him to give an opinion on what caused the damage, highly unreliable, no basis whatsoever demonstrated. He has no facts about that. And it would be hugely prejudicial to admit it, number one. Number two, there's no evidence in this case that the gun left the factory broken, that it was modified with the hammer at the factory. The testimony that you heard from the Haigs, for example, about the FBI testing is whether the FBI broke it or not, whether it was modified beforehand by Seth Kenney. No one thinks that it left the Pieta factory with a hammer ground down or sideways marks on the sear. That's not at all an issue in this case. And again, since it's not at all an issue in this case, would be prejudicial for Mr. Pieta to come in and say, we make very strong guns. We make guns that are quality guns, to give the impression to the jury that, well, this must have been a functioning gun in 2021, because in 2017, after long before many, many things happened to it, it was a strong functioning gun. That's unreliable. That's prejudicial. It's far too far away from the circumstances of 2021 to be admissible.
The court makes the following ruling. The court finds that Mr. Pieta is properly a fact witness. He's not an expert witness. He can testify to his knowledge of the gun before it left the factory. He can say it was a functioning gun if he tested it at that time. I think that you want the court to follow down the meander of strong functioning gun. He's not going to say strong. He's going to say that it was functioning. And I think that the creation or origination of that gun, for purposes of what Ms. Morrissey said, that so that in closing, it's quelled with respect to where's, in so many words, how do we know it was looking good when?
Sorry, folks. We got another update. Apparently, Judge Bev is not going to investigate anything about the jury. The Supreme Judicial Court, she writes, has recognized, this is from Judge Bev, this is from her bench. Why are we not surprised? The Supreme Judicial Court has recognized that the safety of jurors is crucial to the fair functioning of the judicial system, and that the justice system owes them the highest degree of vigilance for their personal safety. This case has garnered significant and divisive attention in Massachusetts and across the nation. The trial was live streamed on local and national broadcasting channels. The proceeding continued to the daily subject of commentary on various social media platforms. People associated with the case have been charged with intimidation. She's talking about Turtle Boy here, of course. This court acknowledges that the names of impaneled jurors who rendered a verdict in a criminal case must be retained in the court file and made available to the public. But the jury in this case did not render a verdict. However, the court concludes that there is a real and present, quote, risk of personal harm to the jurors and to the integrity of their service. Oh my, you mean by the McAlberts? You're afraid that the mafia of the McAlberts is going to come after them? Consequently, the court finds that good cause exists to impound the list, identifying the names of impaneled jurors in the trial of the case. The court further concludes that there is a risk of immediate and irreparable injury should the list be made available to the public at this time. This order shall expire 10 days from the date of issuance unless otherwise ordered by the court for good cause shown. So only if they come forward on their own. Only if they come forward on their own.
Big motion to compel?
Yes, there is the motion to compel that was.
That's the
declined.
latest
You can make
update.
arguments on that, but I'm not going to rule from the bench if you
Yes.
want to do that. Do you want to do that?
It's their motion, sure. Ms. Johnson's responding to it.
Okay. Go ahead. You didn't do a notice of completion of briefing, but okay.
He did submit it, Your Honor, but I can
Okay,
resend
that's
it.
fine.
So, Your Honor, I know that this is unfortunately something that we've brought to the court on more than one occasion, and I know that this is not the time that the court would prefer to hear these issues. However, precisely because we are at the eve of trial is why we have to bring this up to the court again. As the court knows, under the laws of New Mexico, the state has an affirmative duty of production, both under the rules being 5501 and also under Brady, Giglio, and all of those. So it's been apparent from early on in the case that we were not receiving all of the productive documents and discovery that we should have been receiving. We've detailed in our motion the numerous attempts that we've made to try to address those concerns. They were not addressed at any point. And I'm going to focus on the reply that we did submit to the court because the circumstances have now changed to some degree in a fairly material way. And that is that initially we had been corresponding largely with Ms. Morrissey, who had been the prosecutor on this case for quite some time before Ms. Johnson came on. Our requests for production and our concerns about it looking like we had incomplete discovery, like it looked like we had incomplete disclosures, we're constantly met with, you have everything, there's nothing else to give you, or if you tell me specifically what you're looking for out of these, IPRA productions that are redacted, tell me specifically what it is that you want unredacted, and then I'll take a look. The problem with that approach, Your Honor, is that the state, again, has an affirmative duty. It's not a reactive duty. It's not that the defense has to first try to guess at where there might be additional discovery that we're entitled to, what Brady information might be out there. The state has a duty to take it upon themselves to review the documents and the discovery in their possession and to turn over anything that falls under 5501 or their other affirmative disclosure obligations under Brady, Giglio, and their progeny. So what we did was, realizing that we were getting nowhere, again, after all of these months, we had dealt with IPRA to try to take it upon ourselves, even though it's not our obligation, to try to get more documents. Those came in over the course of about 7 months, again, heavily redacted. And we could tell that there were some documents that certainly appeared to have the type of content that we would be entitled to. But many, many of them had entire sections that were just completely blacked out. So we don't know what the content was at all. We could only see, who the sender and recipient were. And everything was blacked out. So we were left to guess, whereas the state has the affirmative duty of disclosure. And so what we did was then we, for the first time, I believe it was on the 27th of June, reached out, and instead of emailing both prosecutors or just Ms. Morrissey, we reached out directly to Ms. Johnson and only to Ms. Johnson. And basically, under her obligations as a prosecutor now on this case, asked her to fulfill those obligations and do an affirmative review of everything and to turn over anything that needed to be turned over. The same day, in accordance with her responsibilities, she did then respond and said that she was requesting a full unredacted copy of the thousands of documents that we received under IPRA that were still redacted, and that she would undertake an affirmative review of those items, as well as checking for an audit with the law enforcement agency. That same day, after she responded to us with the request that we had just sent her, again earlier in the same day, we started to already get disclosures where Ms. Johnson was saying, I found documents that are subject to disclosure under Rule 5501, contrary to what we had been told from the inception of this case, which was that we had everything that fit under 5501. It was repeatedly told to us, you have everything, you have everything. Yet we received production after production after production, totaling over 1,100 pages from Ms. Johnson over the course of June 27th to June 29th. And in each of these multiple disclosures with numerous Dropbox links, we received disclosures from Ms. Johnson where she indicated, here are documents that are subject to our obligations under Rule 5501, documents that we had never seen before, despite the fact that these documents were not just in existence as soon as June, they had been in existence for months, over a year even sometimes. And we have a number of them, Your Honor, that I will go over. And so these are the types of documents that were withheld. So we have, for example, there were documents that were created on January 23rd, 2023. They were not disclosed until June 28th, 2024. The topic of those documents, and I have them under an exhibit, which actually I believe is attached to our reply. That would be Exhibit N, is comments on whether or not it's customary for actors to be shown what was in the gun. Again, a central theory of the state's case that actors are supposed to be shown the contents of the gun so that they can check whether or not there's a live bullet or a blank or a dummy. And so those were comments with witnesses to this case, and that's Exhibit N that the court can look at. And I do have an extra copy if the court needs an additional copy. Okay, yes, Your Honor. And so we've tabbed them, Your Honor, so that the court can look at the exhibits that we have there. And so, Exhibit N is what I was just referring to. And again, the date of that statement that had been withheld was January 23rd, 2023, almost a year and a half ago. We also have another statement that was withheld November 17th, 2022. That was just disclosed June 28th, 2024. This is Exhibit O. And the topic of this is the benefits and requirements of New Mexico tax incentives. That's the production that was at issue in that one. And again, it's Exhibit O. Another date of withheld statements, December 11th, 2022. Date of disclosure, June 28th, 2024. In this one, these are opinions from the state's own expert, Brian Carpenter, about statements that were made by Hannah Gutierrez-Reed, and this is Exhibit P. So they had these statements and opinions from their expert, Brian Carpenter, since December 11th, 2022, and we did not receive it until June 28th, 2024. Additionally, Your Honor, again, December 11th, 2022, statements from Brian Carpenter, the state's expert, understanding of what happened on the set of Rust and including in the church. That's his own understanding based on what he had looked over. Clearly a statement by their expert. The date of disclosure was not until June 28th of this year. August 21st, 2023 was the date of another statement that had to do with the topic was whether or not shooting lots of blanks might impact the fire control components of a firearm. This is Exhibit L and was with the state's firearms expert being Lucian Haig. And so this is again another statement by yet another state's expert. We did not receive that until June 29th, 2024, despite the fact that they had it since August of 2023. Then we have additional statements from November 10th of 2023 and April 19th of 2023. And these were more states' expert witnesses, the Haigs, opinions related to Mr. Baldwin's handling of the firearm. This is Exhibit L at 2 and 3. The list could go on, Your Honor, but again, we just received these disclosures as we're in the middle of trial preparation on the eve of trial. But we have received, again, over 1,100 documents, and we are doing our best to comb through these to pick out what we have. These are just some of the ones that we've been able to pull out thus far. And these are just the ones that we've received within the last week. As the court knows, this is not the first time that we've been made aware that we were not getting disclosures timely. We had the Haig report that was initially disclosed on August 20th, or that was written on August 26, 2023. We didn't get it to April 29th, 2024. And again, the prejudice for these is we got that after the pretrial interview was already conducted, 1 week before the dispositive motion deadline, and a week before the witness deadline. The third Haig report for August 31st, 2023 was not turned over until May 21st of 2024. And again, this is after the pretrial interview was conducted with the expert, after the dispositive motion deadline, and after the witness list deadline. And the list goes on and on and on and on. We have so many of these, Your Honor. And the problem with this is, the state talked in the beginning, one of the first motions that they referenced, they were talking about there are rules, there are deadlines that are set in place that the parties are supposed to follow. Absolutely. And these are rules
Why aren't they
that
following
are
the
very
same
clearly
rules?
intended to ensure that the defendant has his due process rights fulfilled, that he has the
Yeah.
right to a fair trial, that he has the right to present a defense,
Yeah.
and that he has the right to confront the witnesses against him
Yep.
and be prepared with any statements that those witnesses have made so that he can explore in discovery, so that he can determine whether or not he would call other witnesses, so that he can ask these witnesses about the statements and opinions that they have given, and so that we can actually do something with it, rather than receiving these now a week before we are set to go to trial
Yep.
on a case involving a manslaughter. And so,
Yeah.
Your Honor, at this point,
It's not
it
unreasonable.
is, and I know the court has heard us say this before, and the problem is we've had to say it repeatedly because of the continuing violations, is that it's not something that the court can turn a blind eye to. It's egregious. It's been repeated. It's been throughout the duration of this entire case. And all we've been trying to do is get information that we have been entitled to from day one, or from day 10, I guess, if we're going 10 days after the date of arraignment. But there was always a continuing duty to disclose that whenever they received something new, within 7 days of that receipt, they would turn it over to us. And this has not happened throughout the pendency of this trial. Even now, even though Ms. Johnson has gone through and has reviewed and taken it upon herself to do some of this, there was nothing preventing her from doing it earlier. But it wasn't until we reached out to her directly that she finally waited and wasn't just waiting for Ms. Morrissey to respond. She did take that duty upon herself. She should have done it earlier, but she did do it, and we appreciate that. But even now, there are still documents that are redacted that we know contain statements that we are entitled to, that we still don't have the redactions lifted for. And I have examples here for the court that I can show if I may approach.
Wow, the level of hiding of evidence, if true, this is kind of insane. That is a lot to hide in just one case. That's pretty crazy.
So what I've handed the court, Your Honor, are, again, and these are just things that we're having to affirmatively comb through now on the eve of trial. One that I've handed to the court, if the court will look at, is dated Wednesday, January 18th, 2023. It's a communication from Brian Carpenter, the state's expert. And it says, attachments, statement of PC, being probable cause, Baldwin, with BWC markup comments. This is, we assume, again, Brian Carpenter markup comments. So he's reviewed the statement of probable cause, and this is back in 2023, and marked it up with whether or not he felt that the statement of probable cause was appropriate, was whether or not there were any problems with it. And this is just what we have to assume, because he says he marked it up, meaning that there were changes that he made. So these are clearly statements and opinions by this expert, and yet is entirely redacted still. We can see nothing about it. We see team up at the top and nothing else. So we still don't have his statements as to, and comments as to the probable cause. In addition, number 2, we have the one that starts on March 6, 2023. And in this one, it starts with the big blocked out section at the top of the page. And it's from Jennifer Paget Macias. And she indicates, good morning. We need to disclose the email below in discovery. But before we do, we need to get subpoenas and certificates of compliance out for specific documents. She then goes on to say a number of different things. This has been identified as something that should have been turned over in discovery. And yet if the court flips through it and she says, you know, what follows is supposed to be disclosed, it's nothing but blackened pages. We have none of the contents of these communications, despite the acknowledgement by the prosecutor in that case.
How do you just get like blanket
that was subject to disclosure.
pages?
We then also have additional
Is this for real?
documents. Another one from Jennifer Paget Macias, dated February 20th, 2023, where there are attachments. And this is an inquiry to Brian Carpenter from Miss Macias, where she is asking him whether or not he can look through some documents, these safety bulletins, and let her know if their expert, Brian Carpenter, is familiar with the guidelines, if he has experience following the guidelines, and whether those would have been applicable to the rust production in New Mexico. She says, in other words, do you have personal knowledge as to these standards? Certainly his answer to that is relevant to his qualifications and whether or not he is appropriately an expert. If he has no experience or very little experience with these things that are directly at issue in this case, then he certainly doesn't make an appropriate expert. But we do not know the content of these communications. We don't know what Mr. Carpenter said about whether or not he was qualified because it's entirely blacked out. We have nothing that we
Wow.
can see from this. And in addition, Your Honor, the last one, again, is messages between Mr. Carpenter and Miss Morrissey. These have been blacked out. We have, some just kind of initial back and forth. Presumably, if that's all it was, there would not be further redactions, and yet there are. So here we are on the eve of trial. We still don't have these documents that we clearly have a right to have. And again, on document number 2, actually, I believe there's a portion on the 3rd page where it's like almost completely blacked out. But if you look at the portion, you can kind of see part of the sentence, like half of the word, and it seems to say something about script supervisor and continuity supervisor. That would presumably be Mamie Mitchell, who is a witness in this case and was in Miss Gutierrez's case. Something about required her to keep something costume and something details, but we can see that it's about one of the witnesses who actually has testified in Miss Gutierrez's case and will be
Damn.
a witness in this one. And again, was identified as something that is appropriate for disclosure. So we are here late in the game, and this is not where we want to be. I know this isn't where the court wants to be, but here we are. And it's not through any lack of trying on the part of the defense. It's just that we have been dealing with a situation where we cannot get appropriate discovery. And this is not how it's supposed to work. And so what we are asking the court to do is to recognize that in this case, there have been significant and substantial violations. And in cases where there are egregious discovery violations, dismissal can be an appropriate remedy. Suppression can be an appropriate remedy.
Dismissal.
And while we
though,
would argue for
you're not gonna get your
for
dismissal,
dismissal,
honey. I'm sorry.
we know that the court is not inclined to do that at this stage, but in this type of case, it would be an appropriate remedy, and it is one that is available to the court.
Yeah.
If the court were not to grant a motion for a dismissal, however, there are other remedies that the court can also entertain, and the court should entertain, because when we're looking at the kinds of violations like we've seen in this case, it has materially impacted the defendant's ability to be able to prepare for trial, to be able to interview the witnesses, to be able to seek out its own experts and do whatever it is that we need to do on the case when there have been so many continual discovery violations. So the more narrowly tailored remedy that the court could fashion, even though it would not put us completely in the position that we would be otherwise, the closest that we could probably get is if the court were to look at these topics for which we still have these disclosure issues, for which they've now just disclosed these things from their expert witnesses, again, the week before trial when they've had some of these for over a year, and say, I see that there is prejudice, I see that there were violations, and there's prejudice to the defense. So we will not allow the state to benefit or to put on these topics of evidence because the defense is not in the position that they would have been had these documents, had this discovery been disclosed in the timely manner
Not
that they were
unreasonable.
supposed to be. And frankly, while we still want disclosure now, and we are asking that the court lift the redactions and ask for an in-camera review of the documents that we've provided as the exhibits that we still have that are redacted, that we don't have the ability to see the contents of, we would ask that the court lift those redactions. so that we can see what's in there. But there is nothing that can cure the fact that these things have been disclosed so late in the day that there's not much we can do with them. So we are asking that those topics that I've outlined in Exhibits N, O, P, and L, that the state not be permitted to introduce evidence or testimony related to those topics, since we are at a disadvantage because of their withholding of this information. And we would also ask that, similar to the other motion that we had done where the court ordered that the jury would be informed of the violation with respect to the Hague report, for example, we're asking that the court allow us to submit a similar instruction with respect to their violations in this instance, so that the jury can know and actually draw their own inference that this information would have been helpful to the defense had they been able to see it.
So you're asking me for 4 solutions. One is to dismiss the case. The second is to eliminate subject matter. The third one is that, which is ongoing, is for them to keep going, keep looking. And then the last one is
The inference instruction.
what you're asking for is a continuance. So why don't you come out and say it? Because you don't want one.
We
How
don't,
are
that's
they
correct.
going to
Wait,
keep looking for things without a continuance?
What we're asking, Your Honor, for right now is those specific documents.
She doesn't
that are
want a
provided to the
continuance.
court.
4 things, okay? And I'm asking you, how is that not going to help if I don't give you a continuance? You are essentially asking for a continuance because you're saying they have to keep looking. We have 8 days of trial and they have to keep doing this. What does that mean? How does that compute?
So, Your Honor, so what we're asking for is not actually a continuance, and we're not even asking for those extended things. What we're asking for is we've identified a discrete number of documents right now.
You've got to adjust your request then.
Okay, Your
What
Honor,
is
so
it?
let me try to do that then. So what we've handed to the court is a number of documents that still remain redacted. We cannot see the contents, is what we've provided to the court. We're asking that the court lift those redactions, or order that the state lift those redactions, so that we can see what those are, because those are clearly discoverable and yet we still don't have the contents. That's one request that we're making. The other request is related to exclusion of subject matter, and that's because we don't want a continuance. We don't want a
What is the
continuance.
subject matter you want?
The subject matter, Your Honor, that we're asking the court to not permit are those subjects that are included in those exhibits that I just detailed for the court. And so that would be. And so, Your Honor, what we would like to do at this point, because we understand, again, this is a difficult position. It's difficult for us. It's not where we want to be. It's difficult for the court, because here we are at the eve of trial. We don't want a continuance. The court has already ordered us to meet and confer. My understanding actually from Mr. Spiro is that the state had indicated to him, I guess a moment ago before we argued this, that they have some additional disclosures that they would be making. I don't know if that includes potentially what we're asking for with respect to lifting of those redactions. I'm not sure what that involves. I wasn't part of the conversation. So we may be able to get something out of a meet and confer where some of the remedies that we're seeking may already be addressed. So if the court would allow us to do that meet and confer, then perhaps we can bring this again before the court once we know what situation we're in currently.
Thank you. State.
she has already ruled in her mind.
Thank you, Your Honor. Your Honor, first, as the court knows, I'm somewhat newer to this particular case, but the state has complied. I did receive the request, and Ms. Morrissey didn't have the unredacted IPRA. I requested the unredacted IPRA. We went through all of those documents and made those disclosures. They have the information, and the information that they want is information they're not entitled to. So they received information that was subject to disclosure under 5501A6, 5501G, and these are emails is what we're talking about. They're emails with witnesses. And just to give you an example, Judge, I brought the unredacted, and I'd like to give it to the court for an in-camera inspection. And you will see they're not entitled to it. They're not entitled to that information because it's not statements from witness. For example, the email where Ms. Padgett says, we have to disclose this. Well, it's actually the contents of what the person, it's a paralegal emailing the DA's office. That's not a witness statement. And it's just basically saying, hey, we need to get these things and they need to be disclosed. So if the court would like to take a look at it, Your Honor, for an in-camera inspection, if I may. Well, no, no, Your Honor, because it's for an in-camera inspection, just for the court. So it's the last page, Your Honor, where
Oh, I'm good. Thank you.
it begins after Ms. Paget signs, "Thanks, Jennifer." It's a very second to the last page. You'll see
Housekeeping.
It's an email from a paralegal at a law firm. They're not entitled to that. What the defense is complaining about is they want communications between the attorneys. They want communications between paralegals and the attorneys. They're not entitled to that. They're not entitled to our strategy. They're entitled to witness
How
statements.
would they know that? Why can't you tell them they're not entitled to this?
I did,
Because
Your Honor. I went through and I disclosed numerous disclosures. And I specifically in those emails stated, and they attached them as exhibits, these are being disclosed because they were found to contain information that is subject to disclosure. So if it's still redacted, it's not subject to disclosure. And so the other documents, Your Honor, I'm happy to submit those to the court for an in-camera inspection.
I'm not going to do an in-camera inspection. I'm ready for trial,
Yes, Your Honor.
okay?
And I understand. And what I'm telling you as an officer of the court, as a representative of the state, I went through these.
Why so late?
Your Honor, I was requested on June 27th to do, because
Well, I'm asking the state in general.
Ms. Morrissey didn't have a copy of the unredacted IPRA, Your Honor. So a lot of these happened
Why did you
before.
give them IPRA?
Well, what happened was the defense requested an IPRA in October of 2023. Mr.
Well, you
Baldwin.
knew what was going to happen with that. Balloon.
Yes, and Mr. Baldwin wasn't charged at the time. So that when they received the production from the state, he was then at that point charged. I believe it was in May. They asked Ms. Morrissey, would you please unredact? Well, it was thousands, as you noted. Ms. Morrissey asked, tell me which ones you want unredacted and I'll take a look at them. She received no
This is
response.
all about the IPRA. Is this correct?
It's a,
This
yes,
is all
it is.
about the IPRA.
It is.
This isn't about any other discovery that
This
was
is
disclosed.
so crazy.
Except what was disclosed in the IPRA.
Yes, and they're witness statements. That's what it is. So a proper remedy, Your Honor, under Harper is a continuance. It's a continuance. They have the information now. As far as the third Hague report, the court addressed that in the Brady motion. As far as this is concerned, they're statements. And the state has gone through, disclosed to what,
Have you already given them the statements?
that's what was unredacted. That's what we went through and
Well,
unredacted.
what other redactions does she want?
She wants essentially what I just handed to the court.
in-camera, the ones that you said you can't do.
Exactly. They're,
Well,
what they're,
you'd have to make, if they responded that this is privileged information, I can't do it for you. You're gonna have to make arguments on why the redacted portions of the IPRA request that she has kept redacted are fair game. And this is all about IPRA is what I'm understanding.
they're statements that were obtained, yes, Your Honor, emails. There are thousands of pages of emails. And so, Your Honor, the proper remedy, they haven't shown how they're prejudiced.
So obviously you can tell the court is not happy with this. We are in recess, go confer, and I'll see what's going to happen. I will
Oh.
give you an hour.
Thank you.
Wow.
Recess.
Oh my God, dude. Unbelievable development. So the defense wants documents, unredacted documents that they should have received a long time ago. And now the proper remedy is to give the defense proper time to receive these documents, review them. The judge wants to move forward with trial. And she doesn't want a continuance. She's given them 1 hour to confer. And during this hour, they are going to decide whether or not they can come to some sort of an agreement. If they can, Fantastic. Trial begins tomorrow. If they can't, I may have flown to New Mexico for nothing. Well, I shouldn't say nothing. Not completely nothing. Chandler got a chance to be in courtroom today, so that is fantastic. But she is so unhappy. I want to watch this
Still
portion
have
again.
these disclosure issues for which they've now that we've provided. We will stop information that's been helpful to the defense for the court once we know what situation we're in currently.
Thank you.
I want to watch this again. Because the state is where it
Thank you,
really.
Your Honor. Your Honor, first, as the court knows, I'm somewhat newer to to this particular case, but the state has complied. I did receive the request, and Ms. Morrissey didn't have the unredacted IPRA. I requested the unredacted IPRA. We went through all of those documents.
Inspection of
and
public
made those
records
disclosures.
request.
They have the information, and the information that they want is information they're not entitled to. So they received information that was subject to disclosure under 5501A6, 5501G, and these are emails is what we're talking about. They're emails with witnesses. And just to give you an example, Judge, I brought the unredacted, and I'd like to give it to the court for an in-camera inspection, and you will see they're not entitled to it. They're not entitled to that information because it's not statements from witness. For example, the email where Ms. Paget says, we have to disclose this. Well, it's actually the contents of what the person, it's a paralegal emailing the DA's office. That's not a witness statement. And it's just basically saying, hey, we need to get these things and they need to be disclosed. So if the court would like to take a look at it, Your Honor, for an in-camera inspection, if I may. Well, no, no, Your Honor, because it's for an in-camera inspection, just for the court. So it's the last page, Your Honor, where it begins after Ms. Paget signs, "Thanks, Jennifer." It's a very second to the last page. You'll see it's an email from a paralegal at a law firm. They're not entitled to that. What the defense is complaining about is they want communications between the attorneys. They want communications between paralegals and the attorneys. They're not entitled to that. They're not entitled to our strategy. They're entitled to witness
How
statements.
would they know that? Why can't you tell them they're not entitled to this?
I did, Your Honor. I went through and I disclosed numerous disclosures. And I specifically in those emails stated, and they attach them as exhibits, these are being disclosed because they were found to contain information that is subject to disclosure. So if it's still redacted, it's not subject to disclosure. And so the other documents, Your Honor, I'm happy to submit those to the court for an in-camera inspection.
But the judge is like, no, I don't want an in-camera
inspection.
inspection. Yeah,
I'm ready for trial.
I'm ready for trial.
Yes, Your Honor.
Okay.
And I understand. And what I'm telling you as an officer of the court, as a representative of the state, I went through these.
Why so late?
Your Honor, I was requested on June 27th to do, because
Well, I'm asking the state in general.
Ms. Morrissey didn't have a copy of the unredacted IPRA, Your Honor. So a lot of these happened
Why did
before.
you give them IPRA?
Well, what happened was the defense requested an IPRA in October of 2023. Mr.
Well, you
Baldwin.
knew what was going to happen with that. Balloon.
Yes, and Mr. Baldwin wasn't charged at the time. So that when they received the production from the state, he was then at that point charged. I believe it was in May. They asked Ms. Morrissey, would you please unredact? Well, it was thousands, as you noted. Ms. Morrissey asked, tell me which ones you want unredacted and I'll take a look at them. She received no
This is
response.
all about the IPRA. Is this correct?
It's a,
This
yes,
is all
it is.
about the IPRA.
It is.
This isn't about any other discovery that was disclosed except what was disclosed in the IPRA.
Yes, and they're witness statements. That's what it is. So that a proper remedy, Your Honor, under Harper is a continuance. It's a continuance. They have the information now. As far as the third Hague report, the court addressed that in the Brady motion. As far as this is concerned, they're statements. And the state has gone through, disclosed to what
Have you already given them the statements?
That's what was unredacted. That's what we went through and unredacted.
What other redactions does she want?
She wants essentially what I just handed to the
in
court.
camera, the ones that you said you can't do.
Exactly. They're
Well,
what they're
you'd have to make if they responded that this is privileged information, I can't do it for you. You're gonna have to make arguments on why the redacted portions of the IPA request that she has kept redacted are fair game. And this is all about IPA, is what I'm understanding.
they're statements that were obtained, yes, Your Honor, emails. There are thousands of pages of emails. And so, Your Honor, the proper remedy, they haven't shown how they're prejudiced.
So obviously you can tell the court is not happy with this. We are in recess, go confer, and I'll see what's going to happen. I will give you an hour.
Thank you.
We're in recess.
Everybody knew that their trial is set to begin, and they have this IPRA public records issue that, inspection of public records requests. That's what IPRA stands for. It's not HIPAA. So the only thing that I might be disappointed about is if this case doesn't go to trial tomorrow and I flew to New Mexico for nothing. I may be able to get some refunds, but the hotel was prepaid, so I'm not paying on a daily basis. And James from court, God, I gotta call James. I don't know if he's been watching this. Yeah, we are live, folks. We are live. This is an absolute nightmare. It really is. James is not picking up. He's probably in the air.
Your call has been forwarded to an audit.
Yeah. Oh, man. The chances of the judge granting a continuance, I'm putting at about 5%. 5%. Maybe because I'm biased. Thank you, Matrix, for the one gifted. Shout out if you got a gifted membership from Matrix. Time Lord Cloud says, what is the old saying? It is better to let 10 people go than to put a single innocent person in jail. But our justice system is so broke that it will put an innocent person to jail now. Yeah. Sadly. Yeah. Andrew is asking for a too long didn't read on where we are right now. So we've had a slew of motions filed by both sides this morning. Motions in limine, very standard stuff. Certain testimony to be excluded, certain witnesses not to say certain things, certain pieces of evidence to be played or not to be played. And for the most part, I think the judge has ruled very fairly. I mean, she seems to be. It's funny. Somebody wrote this judge is a defense judge. I don't think she is. She's not a defense judge. She's a fair judge. Isn't that stupid? That now, whenever you are making fair rulings, you're accused of being a defense-friendly judge. It makes no sense at all. But anyway, I like her. I like her. She seems to be fair. She seems to be ruling in a direction that I believe is fair to both sides. And she's actually looking at the law. She's listening to the lawyers. She's not being biased like Auntie Bev. But then when they came to the IPRA issue, which is the inspection of public records request, here's the TLDR. The defense filed an inspection of public records request for certain types of emails back in October of 2023. Back then, Baldwin was still not indicted. Baldwin got indicted, I believe, in February. And this trial obviously followed. Trial is set to begin tomorrow. The defense has argued that they have not received these emails that they requested almost 10 months ago. And they want those emails that they requested 10 months ago. Give us the emails. Well, the problem is the state wanted the judge to look at the emails in camera for in-camera inspection. What does that mean? That means, judge, here, you take a look at them and you decide whether or not we need to turn them over to the defense. Well, the problem is that's a very, very arduous task, and the judge doesn't want to undertake it. You know what? I don't blame her. She may seem a little lazy, but to be honest, it's not really her job. I mean, it is, but this is a little too close to trial. Why is the defense making this motion now? After they made a slew of motions to dismiss that they lost consistently on, now she's making another motion to dismiss. First of all, you're going to lose the motion to dismiss, but you have to make it. As a defense attorney, I know. You make the motion to dismiss, you lose on it, and you move on. But the thing is, the defense, first of all, should have made that motion a long time ago. The remedy for them not having ample time to review the evidence and to decide what needs to be unredacted, what does not need to be unredacted, and the state claiming that these documents should remain redacted. And this is the in-camera argument. Judge, look at them in your chambers. You'll see why the defense is not entitled to these documents in the first place. Basically, the judge is like, okay, you know what, folks? Go and decide, okay? I'm giving you 1 hour. I'm giving you 60 minutes to decide amongst yourselves if you can reach an agreement, because trial is set to begin tomorrow. Now, notice how the defense clearly made it clear, Your Honor, we are not looking for a continuance. We do not want a continuance. We're not interested in a continuance. We want the trial to begin tomorrow. That's why I'm placing the chances of a continuance being granted, or it's not even granted, that the judge is just going to issue a continuance sua sponte, essentially, from the bench, is at about 5%, maybe even 3%. So, Andrew, I hope that answers your question. I'm not going to lie, it's really like technical stuff that even I had to listen to a second time just to make sure I didn't miss anything. It's not... It just, my heart sank a little bit. When I heard the word continuance, I was like, please don't. It's like, I know I'm biased and it's my own selfish reasons, but please don't. Chandler and I came all this way to New Mexico. Oy, what a mess. What a mess. And meanwhile, we got the Karen Reed crap show going on. Oh, finally, Aiden's tweeting. I've been waiting all day for this guy. Oh, come on. I can't say anything. He was at his mother's funeral. Mother effer. He was at the funeral. Yeah. What are the chances Bowles didn't have some of these? Looks like her appeal may be more appealing. What? Who is Bowles? You've lost me a little bit. Objection requesting clarification from the audience. I'm not exactly sure what you're talking about, Tracy. I'm sorry. Hannah's attorney. Oh, sorry, I didn't know his name. Oh, for the Hannah Gutierrez trial. Oh, okay. Now your question makes a lot more sense. Thank you. What are the chances that Bowles didn't have some of these? I mean, we don't know if it's relevant to her defense or if this is specifically Baldwin. It's hard to change gears, and we've been we've been bouncing in our heads all day today. We have been bouncing like literally three things going on: the Hannah Gutierrez trial, the Baldwin trial, and the Karen Reed case. Aiden Carney went to his mother's funeral today, Turtle Boy. His mom passed away a few days ago. He was trying to keep it under wraps, but it became public knowledge, public information. So, yeah, it's really sad, Daffy, because the McCabe stands have become like they've been ripping him relentlessly. I'm hoping he's doing okay. I texted him. He says he's doing all right, for what it's worth. Okay, so we have about 40 minutes until the court comes back with a decision. We're going to keep this stream going. I don't plan on terminating it or anything. Michael Proctor has been suspended without pay. No more pay for Proctor. Yeah. What a day. What a day. His salary has been rehomed. Proctor's badge would look so good as a trophy on your wall, sir. I don't deserve it, man. I don't deserve it. I told you. Thanks, Fraud Wrangler. But seriously, I don't deserve the badge. I didn't do anything to earn it, other than rip the guy a new one on my channel. If anybody deserves it, it's Alan Jackson. But Karen Reed has been found unofficially not guilty on counts 1 and 3. Yeah, that's a good question. How supportive is his wife now? Anybody want to go to her Instagram account? Liz Proctor. I don't know which one it is. There's like 1,000 Liz's. What's up, B Kentucky Blue? Liz, I support my husband Proctor filing for divorce in 3, 2, 1. No, I don't think she's gonna file for divorce. If anything, she's just gonna pound him into submission every day. Yeah, I heard about this. Andrew. That's What the Hales are good friends from the South down in Florida. John Crook. John Cook is his real name, but everybody calls him John Crook because What the Hell's nicknamed him such. Back the blue till it happens to you. Isn't that funny? You know how you guys are not ready for me to say this. Imagine if the Thomases oversaw the Karen Reed trial. I think I actually would have preferred that. Anything is better than Auntie Bev. I think if we had a rock, if we just had like a rock on the bench making all the decisions and making all the rulings, that would have been better than Auntie Bev. Judge the Thomases, I'll take 10 times out of 10. I would put Judge the Thomases on that bench, honestly. Just put a rock up there, and the rock would do a better job than Auntie Bev. Excuse me. It's so disappointing. Yeah, he'd just be rambling. He'd be the one testifying. He'll provide all the evidence, but I think he would have been fair to the defense, honestly. He wouldn't have let him speak, but it would have been fair. Goodness me. Everybody and their mother. Everybody and their mother is what was I going to say? Sorry, my brain lagged. Everybody and their mother is doing something. Oh yeah, the corrupt judge in the Young Thug trial. Yeah, that is another, like, what is going on with all these judges, man? Like, this one judge gets a federal lawsuit slapped on her because she goes to conduct a execution of a warrant to search a man's house in a divorce case, and has to pay up $200,000. Then you have the Young Thug trial, who the judge is found to have an ex parte, meaning out of court communication with the prosecution. The defense catches onto it, and he throws the defense lawyer in jail. And the feds have to come in and stop the trial while they investigate. Or the Supreme Court or whatever. I mean, it was a federal intervention, not like FBI feds. And then we have Auntie Bev, who is just refusing to let anybody know about what the split was because she refuses to ask the jury. Then we have Judge DeThomas. I mean, like, these judges are completely out of control, man. We're living in an idiocracy, folks. We are living in an idiocracy. It is now officially confirmed. We live in an idiocracy, and now judges are no longer immune from stupidity. And the female Trump lawyer going after the judge. That one I didn't follow as closely, but that might be another one. Man, it makes me feel like the judges, at least in my state, for the most part, they're okay. They're decent people. Thank you, John McGarvey. I really appreciate you. Even Megan, I went on Megan Fox's earlier, and she was like, there are no state that we can escape to anymore to, like, escape the madness. I'm going to regret saying these words, but what is Project 2025? Consolidate power in the presidency by weakening the independence of public agencies, preparing to replace tens of thousands of civil servants with far-right loyalists, and gutting the system of checks and balances? What is that? It's another part of the idiocracy. Yeah, that sounds like straight up communist, fascist propaganda. What is going on here? Never heard of it. Don't like it. Smells rotten. It's never going to gain any steam. I refuse to believe it. Not yet. To change topics completely, how about them Yankees, huh? I don't know. I don't even do sports. Did the Yankees play recently? When will we see Judge DUI guy? Maybe when I'm close to retirement. People keep telling me I would make a great judge. Maybe. I think I could be fair, although you'll always be judged no matter what you do, pun intended. I think I could be a pretty damn good fair judge, but number one, the salary is crap. You only make like 125,000 a year. I say only, I know, tongue in cheek. I'm an asshole. I'm a lawyer. Get over it, 125,000 a year is your cap, and I hate salaries. I hate salaries. Why do you think I started my own business and my own YouTube channel? Because I don't want limits. I hate limits. I don't want to know. I don't want to go home every day knowing exactly how much I made. Because literally, I would do the math. I'm that kind of person. I would sit down. I would calculate what my paycheck is every 2 weeks, and I would calculate how much I'm going to make over the year. And I'm going to be like, "Is that it?" I would be bored. I'd be bored out of my skull. Oh, Boston beat the Yankees yesterday, 2-0. The more you know. Thank you, Sushi Irish. I have no stake in the game. I follow Iron Maiden. That's my sports team. That's a sports team, right? I don't know. I just bought the shirts. I have no idea what they do. I think they're a baseball team, right? Because iron. Oh, man. Yeah, no matter how many hours you work, it's exactly the same salary. You know what an Iron Maiden actually is, by the way? Let me show you guys. It was a torture device in the Middle Ages. This is what it looked like. This was an Iron Maiden. You would put the person inside of this contraption, and then you would close those doors, and all those spikes would dig into your skin. It is a horrible medieval torture device. You can't fall asleep. You can't move. It is, oh, can you imagine? Ooh, just thinking about it makes me shiver. Being inside that thing. Oh my God. No, not in a good way. Definitely not in a good way. That's an Iron Maiden, folks. Here's another one. Another example. That just looks terrifying. I'm getting claustrophobic just looking at that simile. Yeah. It's funny that like that one doesn't even look that bad unless I'm missing something. No, I guess when the doors close is when it really sucks. Because if the doors are open, you're just like there's nothing there. But the minute those doors close, it's like, oh, you're done. Our ancestors were so creative. Chandler only puts Larry in the Iron Maiden when he has been a bad boy. I mean, you know, sometimes even when I'm a good boy, I get the Iron Maiden. Because why not? You know, it's all fun and games. They're a golfer. That's clever, Amy. That is clever. I like that. I like that. Because iron. That's right. That's right. That's better than baseball. Golfing is better. Yeah. So let's talk about Karen Reed a little bit more because there's just my head is about to explode, man. There's just so much. These jurors came forward. They talked to David. They talked to Alan. They shared some text messages. We had some informants who've been talking to these jurors. Auntie Bev seals their names for 10 days, after which they could be unsealed or she can renew it. So nobody can come to the courthouse to fetch their names. But they can voluntarily talk to the media or a journalist, such as myself. I think they should. I absolutely think they should. But the question is it going to happen? And my fear is that it won't. My fear is that it won't. At least not yet. They're not ready yet. They're too scared. They admitted it themselves in text messages. They're scared of Brian. Why was Brian Albert sitting in the courtroom? They couldn't figure that out. They couldn't understand it. The manipulation worked. The brain scrambling worked. The influence worked. Son of a gun. Son of a gun. All right, we got about 20 minutes left of the 1 hour that the judge gave to the Baldwin lawyers in the prosecution. Her name is Judge Mary Marlowe Sommer. Excuse me. Brian Albert's role, we suspect, was directly involved in the murder of John O'Keefe because it was in his house, in his basement, with his dog. He's friends with Brian Higgins. They're the ones who were squaring off at the waterfall. And Brian is the one who probably helped commit the murder and probably helped to move the body. He's the mafia ringleader. This is a good way to put it, Sushi Irish. Yeah. Crazy. Very, very crazy. Didn't Higgins go on vacation, or was that an old photo? I thought I saw a photo of Higgins like at the airport recently. Yep, and Proctor was suspended with no pay. Yes, Sushi Irish. I did get to the Karen Reed trial. I was supposed to be there 3 times, but I was only there twice. I was there for like a week and a half, but I only got a chance to get into the courtroom once because there was a very small courtroom and there was only family and media allowed. And for me to get media privileges would have been a mess because Massachusetts is corrupt and only allows their own into the courtroom. Aiden was able to get his media pass finally, but he's got a website and all that. So once he got his lawyer involved too, by the way, he was not able to get in without getting his lawyer involved. But then I came back, or excuse me, I was supposed to come back. So I was there for jury selection. That's when I met Kelly Reed. Then I was there, like I just said, for the 2 weeks and got in for 1 day, unfortunately. And then I was supposed to come back on the 13th of June during the trial, but unfortunately, I got COVID and I was sick for a couple of weeks and I didn't want to get everybody sick, so I stayed home. Brian Albert is retired. Yeah, Jenny Lou, that is a very apt point. The Karen Reed case is weighing on your mind every day. Can you imagine what it's doing to her and her family? I got a text from her sister, from Karen's sister. She said that, she sent me the article of Proctor getting suspended without pay. That was really nice to get. I already knew the news, but I didn't say anything. I was just like, you got it, sis. I'm very happy for them. I really am. Kelly is a really good person. I like her a lot. I like that family in general. I got a chance to meet them, hang out with them, have lunch with them. They're really good people. Karen was, well, the lawyers already, so I imagine the lawyers communicated with Karen. So I wouldn't say it was a week. She was only duped for a couple of days. She was only duped for a couple of days. Because Alan got the first text message on June 2nd that the juror reached out, and then Yannetti got reached out by the other 2 jurors the following day, is my understanding. Becky Holland says, so glad you're feeling better. Enjoy your videos. Thank you for all your work. You're welcome, Becky. Thank you so much. Thank you for your support. Very, very much appreciate you. The next court date, by the way, in the Karen Reed case is 2 weeks from today, July 22nd. So it remains to be seen what is even going to be said in that case on that day. But I guess we shall see. Because at the end of the day, I mean, the Commonwealth has still indicated basically we don't care. We are moving forward with the case, right? With the prosecution of Karen Reed. Turtle Boy was at his mom's funeral all day. No, that microphone is back home. It is really, really bulky, and the whole setup, unfortunately, is going to be my in-home studio only for now. I have my travel setup with me. So people have been asking me about this. What are my thoughts on the Idaho 4? The thing is, I don't know enough about the case. I haven't followed it at all, except in the very, very beginning. This is the Brian Koberger case. All I know is Brian Koberger allegedly had like some sort of aspiration to get a degree in criminology. And they found some posts of his and articles that he wrote. If I had, committed a murder, this is how I would do it, or something like that. Or no, sorry, no, that wasn't him. It was another guy. No, he did the polls, right? He did the polls of these people. How would you commit the perfect crime? How would you commit the perfect crime? Or something like that. And he got a bunch of responses, and then he decided to kind of test the theory, I guess. How do you commit the perfect crime? It's very Leopold and Loeb. If you guys don't know the story of Leopold and Loeb, look it up. It's a fascinating story. Clarence there represented them. And got them life in prison instead of the electric chair. There were these two Harvard kids who decided to commit the perfect murder. And so they kidnapped a friend, a 12-year-old boy, murdered him, and left his body by the railroad tracks. Unfortunately, one of the boys was wearing custom-made glasses, and he lost them near the body. And when they found the glasses, it was very easy to find who the glasses belonged to, because there were only a few glasses makers. That's Leopold and Loeb committing the perfect murder. So allegedly, Brian Koberger is like the reincarnation of Leopold and Loeb. But I don't know for certain. He broke into the dorm and killed 4 students. 3 females and 1 male, I believe. Something like that. JWR fan says, question, did you address Karen Reed's motion for dismissal? Yes, we scanned through it. I didn't actually put it on screen or nothing, but we kind of scanned through it. On the main charge that they voted not guilty, they were 12-0. On the main charge, and the first included alleging juror informed them they voted 12-0 not guilty on those, and the retrial equals DJ. Double jeopardy. Yeah, we talked about that for sure. That is huge. That's been some of the, I mean, that is bigger than Proctor getting suspended without pay. That is bigger than that. You know what I mean? It's huge. What's up, Tex? Good to see you, brother. All this stuff that we've been recently seeing with respect to these cases, it legitimately makes me want to move to like another country. Do you guys feel that same way sometimes? I mean, don't get me wrong, it's still the best country to live in. America is, no question about it. But sometimes I look at the stuff that's happening around us and I'm like, I need to go like anywhere but here. Do you guys ever get that feeling? Or am I the only one? I don't know where I would go. Does make you contemplate, doesn't it? Green-eyed Southern girl is like every freaking day of my life. Okay, I guess I'm not alone. All right. I have my crew. I have my crowd. The best chat on YouTube. And yes, unfortunately, nothing will happen to Auntie Bev because she's got complete immunity. Oh. Well, hello. James from court has appeared.
Hello?
Hey, James, say hi to the chat.
Oh, hey, everybody.
So listen, man, we are literally sitting ducks right now. Have you been watching?
Yes.
Okay.
I stopped watching a couple hours ago.
Oh, so you missed the juiciest part.
Yeah. So as I said, though, I thought where you talking about something else happened besides them excluding his role as a co-producer.
Yes. So here's what happened. The defense said that there were some emails, and apparently when I say some, I mean thousands of pages of emails. And the the prosecution argued that they're not entitled to receive those emails because in their unredacted form, because there's a lot of information that the defense is not entitled to. Well, the prosecution offered to present those emails for the court to review in camera, and the judge refused. And she basically said, defense attorney, are you asking for a continuance? She's like, no, I'm not asking for a continuance. I don't want a continuance. And she's like, okay, well, then what's the remedy? If you didn't get them and you requested them in October and it's now July, the day before trial, like, what do you want me to do? And she's like, well, we want them turned over. And the prosecution's like, no, they don't get a piece. They don't get them to turn over. They don't get to look at them. And the judge is basically like, look, the trial is supposed to start tomorrow. So are you asking me for a continuance, which means like trial wouldn't start tomorrow? And the defense lawyer was like, no. We're not asking for a continuance. We don't want a continuance. We're not asking for one. We just want the shit. To give us the stuff. And the prosecutor's like, no, they don't get the stuff. So now the judge took an hour break, and we're actually almost up on that 1 hour. We are approximately, let's see, they took a break about 58 minutes ago, give or take. So in a few minutes, she basically said, I'm giving you guys an hour, go sort it out, figure it out. I'm done babysitting you two, and we'll reconvene in an hour. So we've been on break with the court, and there is a chance, James, there's a chance that trial will not start tomorrow.
It would not be the first time that I was right, Larry. I will say that. That's not good. I mean, what are these emails in regards to?
I am not exactly certain. The defense made a very lengthy argument, and I was trying to keep up, but I'm diving into this head cold. So, what I do know is that the defense wants them, the prosecution doesn't want to give them, and the judge doesn't want to play intermediary. She just wants the trial to start tomorrow. But she said she was not happy. The court is not happy.
Well, I can imagine if they've probably known about this for a while, it sounds like the defense might be just using this, even though, of course, they're saying they don't want to delay it. They could just be using it as a tactic to delay it inevitably. Well, not inevitably, but delay, to just cause the delay.
Right.
To create an inevitable delay, at least for the short term.
We'll see. I mean, I already told my audience I expect the chance of a continuance. First of all, the defense said we don't want a continuance. That was explicit. The judge was like, well, why aren't you just telling me what you want, counselor, that you want a continuance? And the defense attorney, because there's several of them that they just alternate. This was the female one, the brunette. And she was like, no, I don't want the continuance. And the judge was like, okay, so what do you want me to do then? And she's like, well, give us the stuff. And she's like, and then she heard from the prosecution. And again, the prosecution's like, we'll let you review it in camera, meaning in your chambers, judge, but we are not turning over the documents to the defense. We're sorry, kind of thing. And in their unredacted version, only the redacted versions, which they do have. They do have in their possession. And they only received it like a week and a half ago, which is another weird thing. It was like the 27th, she said. Something like the 27th. June 27th was thrown around a few times. But anyway, the prosecution doesn't want a continuance. The defense doesn't want a continuance. The judge doesn't want a continuance. But the only remedy when there's a violation is continuance. And court's back in session. Let's see what the judge says.
Yes, Your Honor.
All right, man. I'll hook up with you in a minute.
For the court, if I may quickly.
No, good job. Thank you for keeping me updated. I'll be there for a couple
The
days.
state
You got it, buddy.
Hopefully,
gave
unless the
us
trial's
the
delayed.
sense of
Yeah.
the witness order,
All right,
Okay.
bye.
which showed us that the witnesses that involve these IPRA issues are the end of the case.
Okay.
So because of that representation, and they were helpful actually in just laying out
The end of
the
the
entire
case.
witness order, more or less. And so because of that, it gives us a little bit more time to meet and confer between ourselves. And the state's also willing to take a sampling of our IPRA issues. And we keep calling them IPRA, but just so the court understands, they're the normal discovery. They just came in and just right. So they're going to take them and look at them themselves in camera and give them a second look. And I'm hoping between the witness order and that, we will not burden the court further with this issue.
Okay.
In
Awesome.
addition, I had held our opening motion in abeyance to meet and confer about the exhibits. The parties have reached an agreement as to the 8 or 9 exhibits each side is using, so that will not be an issue during opening statements.
Okay.
And finally, we were able to meet and confer about voir dire, and
I like it.
The state can correct me if I'm wrong, but one issue that you voir dired about in the last case that we think, at least I will.
Let me just go
Sure.
back up for a minute. So for the record, Ms. LeBlanc asked for 4 remedies. And I'm understanding that you have abandoned that request and you're satisfied with the compromise of witness order and that the state will take a sampling of IPRA issues in camera.
Yeah, we were holding, obviously, time will tell about the.
Well,
The-
that's
the-
not going to work for the court.
We
What?
expect that to resolve the issue. Obviously, we can always bring an issue back. As I said before, we don't intend to bring this back to the court. So I would say that it is mooted or held in abeyance for now. Obviously, they just gave us a Giglio disclosure, which was also helpful.
Well, what I'm trying to avoid
Yes.
is that this continues through the trial. And that's why I think a continuance would be the answer if it continues through the trial. And I want to do it now, obviously, if this is going to continue. So you all have to have resolved it.
Yes, it's my impression, based on the representations from the state, that they don't have any further disclosures, that they're willing to do this in camera in good faith, and that they're going to give us more advanced witness order notice than they would have necessarily been required to do. We believe that has resolved this issue.
All right.
Okay.
Like an order regarding the motion.
Yes, Your Honor.
And I would like you to prepare it.
Yes, Your Honor.
Okay.
So can I just turn to that final quick issue?
But if it's going to say being held in abeyance, I'm not going to sign it.
Yeah,
And I would like that tomorrow
yes, Your Honor. I won't use the
before the
word.
jury's sworn.
Understood, Your Honor.
All right.
The final issue that Your Honor raised before our original break today was the voir dire and how to run it, and
Yes,
any
yes.
insight we had. The parties were able to confer on that too. And in the Hannah Gutierrez Reed case, you did the voir dire regarding guns.
I did?
I think so. I think you made that one of your questions to the panel. I could be wrong. I was.
I don't think so. I usually would not do that.
You would have to. Okay.
Yeah.
So that's just one topic that I think may be of the sensitivity and the type of topic that we may want the whole panel to hear and be able to approach on as a topic potentially.
I usually do not conduct any particular question other than what the UJI requires the judge to
Understood.
go through. And it usually stops on, is there any reason why you can't serve on this case? And then I turn it over to you for the specifics. So I don't,
Fair enough.
so what do you say?
Now I'm saying very little because you've just explained to me exactly
Oh,
how
yeah.
my understanding had been that you addressed a couple of these issues yourself.
Of course, I
So-
could have, can't remember it too much. Okay.
And then the only other topic that we're going to raise is just the strong views on Mr. Baldwin in both directions that we're going to ask. We're going to be more eager to ask the court to take people individually on. But other than that, what the court had said made sense, and we have nothing further.
Well, so are you going to ask to speak in private? I'm not sure on what you plan to do on that.
Well, I think that if people have very strong views, if somebody indicates very strong views on Mr. Baldwin, that is the type of topic that I think has the potential to taint the jury pool as a whole.
Oh, so you mean come up to the bench?
Sure.
Okay, you mean come up to the bench
Yes.
versus what, are you going to speak in private? Because sometimes they don't stick around to speak in private. So you want it up at the bench? I just want to get the visual on this.
Yeah, I think that's what we had envisioned, that just, or frankly, if somebody has a very strong opinion on one of those two sort of, threshold issues, that if they raise their hand, it indicated, thank you, juror number 14, for indicating you have a
Yes.
significant concern on this topic. we're going to come back to that juror then in a break, basically, is how I pictured it happening. And if the state pictured something different when we were discussing it, or if the court doesn't want to do it that way, of
No,
course.
but just so you know, how I've experienced this, when people want to share their views very strongly, they will keep raising their hand. They will meander back to what they really want to let you know, even if the question is not germane to that. And so if we say, do you want to speak in private? Sometimes they do not come back and speak in private. So you don't, you'll have to decide what to do with that. They come back for the selection, but they don't come back to speak in private. They don't stick around for speaking in private. So I don't know how you want to do that. I just don't want you to think here that people.
Yeah, obviously if they leave, they're not in the jury. And
No, they just don't speak in private, but then they come back. They don't leave like goodbye and not come back. They, so we'll take a recess and then we'll say, everybody that wants to speak in private, stay over there and we'll call you one at a time. And they just don't.
Now I realize why we're talking past each other a little bit. So the way I've done it, especially in cases that have been heavily followed and there's media involved, is the court clerk or somebody will take, or I can take a roll call, and it'll be 14, 18, 19, 20. They go into the hallway and they say, jurors number 14, 18, 19, 20, please line up at the door during the recess. We speak to them each for 60 seconds during the recess, and then we're done.
Okay. Well, I hope that they do that for you.
Okay. We have nothing further, and thank you so much for the court's time today.
Okay. All right. We are in recess. So tomorrow, what you're going to do is you're going to come up here while we're waiting. Is that where did I get it wrong? Faith, somebody come out. Okay. So you're going to come up here and you're going to wait up here. And then when they say that the jury's ready for us, we'll all go downstairs together. Okay. Don't sit. In other words, do not go in there and sit. All right. Come up here. Yes.
Are you expecting that everyone be prepared to do openings tomorrow?
No, not at all.
Thank you.
We're going to pick a jury and then here. Okay. We're going to,
downstairs,
what?
and we're meeting in Beach.
We are not here. The council, just the council.
I don't know if he's using our.
Why don't they just meet in here?
I just don't know if he was going to use our courtroom.
He's not going to be here.
We're officially switched courtrooms.
I know, but I do not believe, somebody told me he's not here. Huh?
Let me check.
Who told me that? Court TV said that. I'm just trying to get them not to have too many. Is it okay if you all go to the second floor in a new courtroom tomorrow while we're waiting?
Yes,
Okay. All right. It's a much bigger courtroom.
Isn't she
All
so
right.
much better, Jenny?
So 8:30, and then they'll typically call us around 9 to go downstairs. Okay. All right. Thank you. We're in recess. You can bring water and coffee with a lid. Okay.
Thank you, Judge.
Well, you are unmuted, or you are muted. Remember that we always had to deal with. You are muted. I'm gonna miss that language. Ugh. She's a little crazy. I know. I've noticed that too. Right today, she's like, "Huh? What? Who told me that? Voices in my head? What? Huh? What? Huh? Who said that? No, I don't want an ice cream cone. What? Huh?" Oh my goodness. No, all in all, I'd rather have that than you are all set, Mr. Lying Officer. Your next witness, Mr. Lally. I like that shit, crazy. That's my type of woman. Oh my god. I'd rather have this than Auntie Bev 11 days of the week. You know what I'm saying? Every single day of the week. So Chandler should be coming back soon, I imagine. It's walkable, and she doesn't have her phone, so she can't call herself an Uber, unfortunately. I need to keep an eye on my messages in case she messages me. But huh? What? Who said that? No, I'm not gonna go to the game. What? Did you like that? You're all set, Mr. Lying Officer. Oh my goodness. Anything's better than Auntie Bev. It is like 6 p.m. It is like 6 p.m. in Kentucky right now. So it is only 4 p.m. here because we're on Mountain Time. I was gonna do a summary video today, but it seems like there's really not much to summarize. There's really not a whole lot to summarize. We kind of already gone through it. The pretrial motions kind of speak for themselves. The trial is set to begin. End of story. So with that in mind, this is probably going to wrap it up for today. I'm going to be in the courtroom tomorrow. Oh, sorry. No. Flip it and reverse it. No live stream tomorrow. Okay? No live stream. Only tweeting. Live tweeting. There is no footage. No court TV footage tomorrow. Because tomorrow is jury selection. So, jury selection tomorrow. There's going to be no live footage. So, there's going to be no live feed on this channel, according to the judge and according to the media instruction. Or I don't think the judge said it, but the media instruction that we received, the media advisory. They said the press at the courthouse can observe jury selection except during individual voir dire through a court-based closed-circuit audio-video feed in the third floor Division 8 courtroom. There's no video or still photography or audio recordings by the news media permitted of the jury selection. The trial's pool video producer, Court TV, will not live stream jury selection because New Mexico courts prohibit photography and videography of jurors. So that's not going to happen. However, we will do a summary video tomorrow. There's going to be a summary video of the jury selection, and then day one of the trial on Wednesday, there is going to be morning, like today, afternoon, like today, and summary. Okay? So 3 separate live streams are going to happen on Wednesday. So there are going to be 2 today, 1 tomorrow, 3 Wednesday, 3 Thursday, 3 Friday. And then hopefully James from court, you heard him. He said he's going to be here in a couple of days. So I love you all. You're the best. And thank you very much for joining me. I hope. What? Who said that? Huh? I'll see you guys. If not tomorrow, tomorrow evening for sure. Tomorrow, Eastern time, it's going to be 8 p.m. because everything is shifting 2 hours. Okay, so 6 p.m., 2 p.m. What? Who said that? That wasn't me. 6 p.m. is now 8 p.m. Okay? Amy said she's going to allow it. And with that, folks, I'm going to leave you all. Have a safe night, everybody. I'll see you tomorrow. Bye.